It's 8:03 a.m. The Committee on Judiciary and Civil Jurisprudence will come to order. The clerk will call the roll.
Leach.
Here.
Johnson.
Here.
Dutton. Moody. Landgraf. Schofield. Gonzalez. Flores. Hayes. LaHood. Dyson. Quorum's present.
Quorum is present. Good morning, members. Good morning to those of you who've joined us here and those who are tuning in either online or here in the building. As a reminder, anyone who is wishing to testify before our committee today on, for, or against any bill before the committee, I'd ask that you please register at the kiosks located in the hallways, or you can come up here and ask Michael Ramirez. Michael, wave your hand. This is Michael. He's happy to help you out if you require any assistance. We're going to move quickly today through our agenda, members. If you're tuning in or if your staff tuning in from other offices, get down here as quick as possible because we're going to roll. We're not going to take up any pending business today, members. I'm going to call a formal meeting tomorrow morning, either right before we go on the floor or off the floor tomorrow during our daily calendar so that we can vote out pending business, not only from the standing committee but from the subcommittee as well. I just don't think we're going to have... Okay, we'll coordinate with your schedule and we'll work it out. So with that, the chair lays out House Bill 4922 and recognizes Representative Munoz to explain his bill.
Thank you, Mr. Chairman and members. Good morning. House Bill 4922 would place freestanding emergency departments, FSEDs, and their providers under the same standard of proof as hospital emergency departments and their providers in the case of alleged medical negligence. Members, there have been different courts that have routinely applied the willful and wanton standard to FSED physicians after the FSED Licensing Act was passed in 2009. However, in recent years, there have been district courts that have refused to apply this standard to FSED physicians because they are not specifically included in the current statute. FSEDs are not included in the statute, most likely because the law came into effect long before the 2009 FSED Licensing Act. House Bill 4922 would amend the Civil Practice and Remedies Code to include the freestanding emergency department facilities and physicians working in a freestanding emergency department in the application of the willful and wanton standard of care. Thank you, Mr. Chairman and members, and I'll be happy to answer any questions. And I believe there's a couple of witnesses here on behalf of the...
Okay, thank you, Representative Munoz. Appreciate you being here. Members, any questions for the bill's author? All right, we've got two witnesses who've registered positions on the bill and want to testify. The chair calls Jeff Addix and Jack Walker. Morning, gentlemen.
Good morning.
And Mark Bortis, come on up as well. Okay, let's do a panel, and then if we'll come back around at the end and do questions. Jeff Addix, I have you here on behalf of Precision Emergency Physicians, PLLC, and yourself registered for the bill.
That is correct.
Okay, go ahead.
Thank you, Mr. Chairman.
The chair will show Representative LaHood is present. Good morning. Go ahead.
Thank you, Mr. Chairman and members. Again, my name is Jeff Addix, and I appreciate this opportunity to testify on behalf of myself and Precision Emergency Physicians in support of House Bill 4922. Precision Emergency Physicians is an emergency medicine physician group which staffs 3 freestanding emergency medical facilities in Texas. And thank you, Representative Munoz, for carrying this bill. It's been a pleasure to work with your staff. As was stated just a moment ago, House Bill 4922 would amend the Civil Practice and Remedies Code to include freestanding emergency medical centers to ensure that a complainant who brings a health care liability claim against a provider working in a freestanding medical emergency center must prove by preponderance of the evidence that the provider acted with willful and wanton negligence. Now, this willful and wanton standard is in place at this time for hospital emergency departments, and we feel it's appropriate that freestandings should be included in this provision. The current provision was enacted in 2003 when there was no licensure for freestanding emergency centers. That happened in 2009, so we think it's appropriate at this time to include the freestandings. Thank you, and we appreciate your support.
Okay, thank you, Mr. Addicks. Members, any questions? Well, let's move on and we'll see if there's questions at the end. Chair calls Jack Walker. Jack, I have you here on behalf of the Texas Trial Lawyers Association and yourself registered against the bill. Is that correct?
That's correct.
All right, go ahead. Good morning.
Thank you, Mr. Chairman, members of the committee. My name is Jack Walker. I'm the president of the Texas Trial Lawyers Association, here to testify in opposition to House Bill 4922. We strongly oppose this bill's expansion of heightened legal protection for freestanding emergency centers. We do not feel that this expansion would be in the best interest of patient safety in Texas and would primarily serve to shield a largely for-profit industry from appropriate accountability. Texas currently has over 300 freestanding emergency centers. What makes these facilities different from hospital emergency departments is not just their physical separation from the hospitals, but their ownership structure and business model. Unlike the national picture where hospital systems operate a majority of freestanding emergency departments, over 70% of Texas freestanding emergency departments are for-profit operations. In 2009, Texas became the first state to legalize emergency services provided by for-profit companies, not just hospitals. Following this regulatory change, the number of standalone emergency departments jumped dramatically from about 20 in 2010 to over 200 within a few years, and now we have over 300 in Texas. The idea about expanding freestanding emergency departments was to enhance access to medical care. This really has not happened. These facilities have not distributed themselves evenly across our state to meet the greatest need. Studies have found that freestanding emergency departments in Texas tend to be located in zip codes with higher incomes, better insurance coverage, and a greater number of existing healthcare facilities. This pattern raises serious questions about whether these facilities are truly expanding access to emergency care for all Texans or simply maximizing profits in areas already well served by our healthcare system. This legislature has already had to address numerous concerns about freestanding emergency centers. In fact, in 2019, this body passed HB 2041, a consumer protection bill against these freestanding emergency rooms for targeting consumers with misleading advertising and charging unconscionable rates. Extending a heightened legal protection now would create a double standard where a predominantly for-profit business received the same liability shield as traditional hospital emergency rooms, despite not facing the same regulatory requirements, serving different patient populations, or sharing the same charitable mission. This bill would make it hard for injured patients to hold these facilities accountable while offering no clear benefit to public health or safety. I urge you to vote against this bill, and I'm happy to answer any questions.
All right. Thank you, Jack. Chair calls Mark Bordas. Mark, I have you here on behalf of the Patient Choice Coalition registered for the bill. Is that correct?
That's correct,
All right.
Mr. Chairman.
Go ahead.
Thanks, committee members. My name is Mark Bordas. I'm testifying on behalf of the Patient Choice Coalition in support of House Bill 4922. The Patient Choice Coalition is a multi-state organization representing independent providers, physician-owned facilities, and their patients. House Bill 4922 seeks an update statutory provisions regarding the healthcare liability claims against physicians or healthcare providers. When Texas passed tort reform in 2003 under House Bill 4, it did not include licensed freestanding emergency medical care facilities. Due to a lack of licensure for freestanding emergency medical care facilities when tort reform passed the Texas legislature, there was no need for their inclusion. This measure seeks to ensure that the current statute takes into consideration all providers of emergency care furnished in the state of Texas. More specifically, House Bill 4922 amends the Civil Practice and Remedies Code to include a freestanding emergency medical care facility to ensure that in cases involving healthcare liability claims against physicians or healthcare providers for injuries or deaths, the claimant must demonstrate by a preponderance of evidence that the provider acted with willful or wanton negligence. This change aims to ensure that the standard of care expected from hospital emergency departments also applies to freestanding emergency medical care facilities, and this is simply a measure that brings parity among our providers of emergency care. Thank you very much.
All right. Thank you, Mr. Bordas. All right, members, let's open it up for questions. Vice Chair Johnson.
Thank you. Mr. Addicks, since the request is that we eliminate some of the consumer protection in the courthouse, would y'all's entities be open to increasing regulations on you all to bring you up to the same standard as hospital emergency rooms?
Absolutely. We operate as hospital emergency rooms.
You
We
have
our
the
own
same
labs.
regulatory standard?
Yes, ma'am. And I think our licensure provisions are very strict and maybe even more strict than what's in place for hospital ED at this time.
Would you do me a favor?
Yes, ma'am.
I don't know that that's accurate, so I would love it if you would supplement your testimony with the indication so I can go look at the code to see that you all actually either have the same regulatory standard as a hospital ER or that you guys are up to par. That would help me quite a bit.
I'd be happy to.
Thank you.
That was your question? Okay. Representative Flores, you have a question? Members, any other questions for the panel? All right, gentlemen, thank you.
Thank you.
Appreciate it. Does anyone else wish to testify on, for, or against House Bill 4922? Seeing none, the chair recognizes Representative Munoz to close on the bill.
Thank you, Mr. Chairman and members, and with that, I close.
Members, any questions for the bill's author? Okay. Thank you, Representative. Thank you. We'll leave House Bill 4922 pending at this time. Hey, James Fields, it's great to see you. It's great to see you here this morning. I'm glad you're here. The chair lays out House Bill 4256 and recognizes Chairman Spiller to explain the bill.
Thank you, Mr. Chairman. Chairman Leach, Vice Chair Johnson, members, thank you for allowing me to lay out House Bill 4256. HB 4256 allows Texas to protect consumers that are indirectly harmed as a result of a company's anti-competitive practices. According to Illinois Brick versus Illinois, a 1977 case, under federal law, only entities purchasing directly from antitrust violators may seek to recover damages for overcharges suffered as a result of antitrust violations. Since it was decided in 1977, at least 29 states, have enacted statutes that avoid that decision by making it clear that indirect purchasers are eligible to recover damages based on injuries that are passed on to them by direct purchasers. Historically, direct purchasers from companies that violate the antitrust laws have passed on any competitive harm to consumers in the form of higher prices rather than jeopardizing their relationship with the supplier. Then, in Abbott Laboratories, Inc. versus Segura, a 1995 Texas Supreme Court case, the Supreme Court in Texas relied on a provision in the Texas Free Enterprise and Antitrust Act of 1983, instructing that the act be read in conformity with federal antitrust decisions to uphold the application in Illinois Brick, holding that the indirect purchaser rule applied to preclude an indirect purchaser plaintiff recovering damage under Texas law. So House Bill 4256 seeks to provide the Attorney General authority to recover economic damages on behalf or from antitrust violators that do not make direct sales to ordinary consumers. So the indirect purchaser rule has been controversial at the time of its announcement back in 1977, has proven to be problematic. As a result, this Illinois Brick rule results in harm to consumers because direct purchasers most often pass that injury on to ordinary consumers in the form of higher prices, lower quality goods, instead of suing the violator of the antitrust laws themselves. So the application of Illinois Brick prevents Texas Attorney General from recovering monetary damages in markets that involve several layers of intermediaries, distributors, wholesalers, and other middlemen that are engaged in anti-competitive conduct. So this the statute as it currently exists inhibits antitrust enforcement in areas such as healthcare, pharmaceutical, and technology markets. So House Bill 4256 will deter anti-competitive conduct in these industries, allow for recovery of damages on behalf of indirect purchasers. I might also note there are some states that have given and authorized specific causes of actions, individual causes of action against these indirect providers. That's not what this bill does. This bill only allows the Attorney General to seek that. Subject to that, Mr. Chairman, any questions that you may have, I'm
All right.
respectfully reserve the opportunity to close.
Members, any questions for the distinguished chairman? Okay. Thank you, Chairman.
All right, keep it.
You've got one witness. Chair calls Roe Jackson. Mr. Jackson, I have you here on behalf of the Texas Association of Manufacturers. Is that correct?
Yes, sir.
Okay, I have you here on behalf of the Texas Association of Manufacturers registered against the bill. Is that correct?
Yes, sir.
Okay, go ahead.
Thank you, Mr. Chairman. Again, it's Roe Jackson representing the Texas Association of Manufacturers testifying in opposition to House Bill 4256. And y'all know TAM, we represent over 500 manufacturers of all different sizes, including some of our state's largest employers. And Texas manufacturers employ more than 847,000 Texans who earn on average more than $123,000 annually. Good quality, high-paying jobs for Texans. I'd like to begin by thanking Representative Spiller and his staff for their willingness to visit with us about our concerns on this bill. The written testimony that was just distributed has lots of information and some items for further research for you or your staff, but I wanted to highlight 2 points for the committee's consideration. First, I'd like to emphasize the scope of departure from Texas's current direct purchaser standard that this law would put in place. This bill would allow more and varied types of suits against individuals and businesses accused of anti-competitive practices. We believe that during the vetting of this change by the legislature, you may wish to ask what has happened in Texas jurisprudence that would necessitate this new standard. Second, I'd like to note that in 2023, the Texas legislature approved a new civil fine structure for antitrust violators under state law. The fine structure was changed to reflect inflation from the passage of the original act in 1983, but also to increase penalties for larger entities, which gave Texas some of the highest fines for antitrust violators in the country, with maximum fines of $20 or $30 million, depending on the value of the violator's assets or market capitalization. Perhaps it may be prudent to see the effect of the new civil fine structure on antitrust enforcement prior to changing the way that the Attorney General may bring suit under Texas law. And to the extent I'm able, I'm happy to answer any questions.
All right, Mr. Jackson, thank you. Members, any questions for the witness? Oh, Representative Schofield is here. Yeah, Representative LaHood.
Thank you, Chairman. So, I'm reading the bill. How does it, what do you mean by did not engage in direct action with the aggrieved party? Like, what do you mean by that? In your concern, so in your letter, you're talking about how you're afraid that this will open up actions against companies or individuals that did not engage in direct transaction with the aggrieved party. So like,
Sure.
What does that actually mean in pragmatics? I mean, are they not affecting it? Are they not having a role in it? Are they truly just a bystander?
Well, and that's kind of the interesting part about the indirect purchaser rule, right? So currently, Texas is a direct purchaser state, so you can show some link between the harmed party or the party that's alleging harm and the party that's alleged to have made the anti-competitive behavior. This would allow the Attorney General to go somewhere further down the chain of purchase or the chain of interaction to go find harm elsewhere and bring it back to someone that doesn't have a proximate relationship between each other. And there's really no limit on where that is in the chain.
Can you give me an example, a hypothetical that could potentially tie someone in where they didn't have direct harm, where they shouldn't be, in your opinion, they shouldn't be a party?
Sure. I mean, I think it's anywhere where you have maybe a manufacturer, and then the manufacturer is alleged to have engaged in anti-competitive action. And then you've got a wholesaler, a distributor, a retailer, a reseller. So somewhere along that chain, somebody down here who purchased from a reseller, 7 or 8 layers deep, the Attorney General could then bring a cause of action against the original manufacturer alleging anti-competitive behavior, even though the direct relationship between the manufacturer and the eventual purchaser does not exist.
And they never directed that or told them to do that or anything like that?
Well, I think the allegation would be that the original manufacturer engaged in anti-competitive behavior that then later throughout the chain harmed a purchaser.
Thank you.
Representative Flores.
Well, wouldn't it, I mean, if the anti-competitive behavior was up at the top of the chain with the manufacturer, I mean, wouldn't every other layer be impacted by that, and they would just be simply passing that along, the price hikes or whatever, the rigging? And wouldn't that, in the end, affect the indirect purchaser at the bottom of the chain?
And some states have enacted laws. Not to contradict Representative Spiller, but I think I checked last night, there's 34 states in the District of Columbia have recognized that cause of action. But in Texas, you would, if it were the Attorney General to bring suit, as this bill is implicating, it would be direct relationships throughout that chain. Could you prove from the purchaser to the next person up the link, that kind of proximate cause?
If this bill were passed, that would be the case?
No,
or
that's
currently?
current jurisprudence in
Currently,
Texas,
so
I
currently
believe.
they can follow up the chain and bring in all these parties?
Right.
If they participated in whatever?
It's the direct relationship that is important, yes, ma'am.
So they've got to show the complete relationship for every party that they would bring in up the chain. Is that correct? Not, they couldn't just go, wouldn't have to just go to the manufacturer at the top, but they could bring in other parties or go after those? Or am I not making sense?
No, you're making sense. I just don't want to say something that's not accurate.
Okay.
But our regime right now is direct purchaser, so you look for that direct relationship and where that anti-competitive behavior occurred.
Okay. But would the relationship need to be between the ultimate purchaser and all of these, or would it just be the relationship between individual purchasers in the stream?
Yeah, I believe the way that the state Antitrust and Free Enterprise Act is written, it's that direct relationship. So you'd want to see where the anti-competitive behavior occurred and then go to the directly affected party.
Okay, thank you.
Members of the, yeah, Representative LaHood.
Thank you, sir. One last question. So, and I don't think you have the bill in front of you, but is your main concern on page 1, line 11, I know you don't have it, but just for the record, directly or indirectly? Is the indirectly the part you have an issue with?
Yes, sir.
Thank you.
Members, any other questions for the witness? All right, Mr. Jackson, thank you.
Thank you.
Does anyone else wish to testify on, for, or against House Bill 4256? Seeing none, the chair recognizes Chairman Spiller to close on the bill.
Thank you, members. And let me say, I respect Mr. Jackson. He does a great job, and I respect many of the folks that he represents. Let me say this, and he mentions a couple things. One is the penalties that were increased. I'm familiar with that because we passed that last session. And the reason we passed that is because Texas was way behind. The Texas Free Enterprise and Antitrust Act had not been amended in over 40 years. So that's why we address that. But likewise, it hasn't been amended here, and Texas has become a fertile ground for antitrust behavior. And quite frankly, if businesses are acting appropriately, I'm not really sure what objection we would have to authorizing the Attorney General to seek these indirect claims if they aren't acting properly. So, I mean, I just don't understand. If everybody's doing what they're supposed to, in my view, there shouldn't necessarily be an objection to this, because my concern is, and if you understand antitrust, you understand that there are many layers and depths in which these things occur. This allows us to prevent that, because consumers are being hurt. That is happening right now in Texas. And so I think this bill is needed. We passed it out of this committee last time. We passed it off the House floor last time. We sent it to the Senate. They tricked it up a little bit, and we couldn't get it across the finish line. But members, this is a good bill, and I think it's necessary. And I respect Mr. Jackson and his members for the job that they do. But I think we need to stop the bad behavior, and I think this bill addresses that. And I would close.
Okay. Thank you, Chairman. Members, any questions for the bill author? All right, thank you. We'll leave House Bill 4256 pending at this time. Chair lays out House Bill 872 and recognizes Representative Harrison to explain the bill.
Good morning. Thank you very much, Chair.
Yeah, good
members. All right, I'll be brief. Executive management of corporations have a fiduciary duty to maximize shareholder value. When executives engage in ESG practices, they are neglecting their fiduciary responsibilities in pursuit of what is almost always a left-wing agenda that has nothing to do with maximizing shareholder value, and worse, it often diminishes it. As the Heritage Foundation recently explained, ESG policies are a thinly veiled attempt to radically transform corporations into social justice warriors and exclude from the system of global finance, capital, any company or even individual who doesn't agree with the prevailing environmental or social ideology, effectively functioning like a social credit score. As a result, capital is now being diverted to causes and purposes that its investors never intended to support. ESG works to mandate ideological considerations in investments across the board, fundamentally changing the free market as we know it. HB 872 is an incredibly simple bill aimed at protecting shareholders in derivative proceedings where they believe that management has been engaged in ESG in violation of their fiduciary duty. All it does is shift the burden of proof to the company in these proceedings to demonstrate their action or their inaction was in fact in the best interest of the company. That's it.
Thank you, Representative Harrison. I think you've got a few questions. Start with Vice Chair Johnson.
Good morning.
Good morning.
So you want to over-regulate out of the state of Texas for the corporate practice of fiduciary duty for their shareholders?
I said nothing to that effect.
Yeah, you did, actually.
No, I didn't.
So
you
you don't like-
just used the word over-regulate.
Yes, over-regulate. You
That-
are
that is a-
placing
that is a-
the
that is
state
a-
of Texas into the boardrooms of every corporation.
The state of Texas is already in the boardrooms, and to the extent that the state of Texas already requires a fiduciary duty of the management of corporations.
So you say
no.
ESG. What does ESG stand for?
And so there are multiple bills and
What does
multiple other
ESG
states
stay
that have
for?
definitions. I would talk about it in terms of a non-pecuniary perspective.
What does ESG mean? In
What
your
does- what
mind,
does
you're
it
the one
mean?
bringing the legislation. What does
I am.
ESG mean? Because you're the one
me
that
to-
came in here and dropped that bomb and said, hey, ESG corporations, they're not protecting their shareholders.
Well, I think you know
What
very
does
well,
ESG
as
mean?
well as anybody, what the letters stand for.
No, you tell me. What does it
Environmental,
mean?
social governance.
Environmental.
And that is
Okay.
pushing. Yeah.
So
Hang on. Vice Chair Johnson asked a question. Representative Harrison, answer.
I did.
So
Okay.
environmental. So if a corporation wants to make a decision to go into business
Yeah.
to attract a market that has a different environmental view from you, you want to dictate their free market practice in Texas. And I'm just
Wrong.
going to let you know,
Well, that's not correct. It's also not a question, by the way.
really,
It's not a question.
Mr. Harrison, my question is, you spend all of your time at this mic saying performative statements and not actually trying to affect public policy. So let me tell you this is my statement. Do you understand that as a Democrat in the state of Texas, that I am doing more to protect the free market and interest of corporations than the social agenda of which you are imposing on business? So the Texas Miracle is going to continue to work because of people like me that try to stop your performative political extremism from impacting Texas businesses. So my question is, I hope you enjoy it.
Those were two statements,
Representative Dyson,
but two
do you have
statements.
questions?
I do. So Representative Harrison, this shifts the burden of proof, right, to the corporation
Yeah,
in this instance?
yeah, that's right.
Right now, the burden of proof, if I got this right, is comprised of the burden of production, burden of persuasion. So your bill would shift both of those over, right? Are you
I'm
familiar
not
with that?
sure.
Burden
I'm
of
not sure.
production, you don't know what that is? Okay, so burden of production is
No,
the burden to produce actual evidence, and then you have also a burden to persuade the trier of fact.
Yeah, and
that you're
and the
correct.
bill, but to be very clear, Representative, the bill does nothing to change what is or is not considered burden of proof in any legal proceeding in the state of Texas.
Well, it does change it, right? It shifts it.
No, what I'm saying is this bill doesn't change what is the burden of proof. So the definition of burden of proof is not materially affected or immaterially affected by this.
Well, I think it is, because, so when we deal with breach of fiduciary duty, and I think you brought that up as
I
one
don't
of the
think you're
claims.
understanding my response.
I do understand your response. I don't think you understand your bill and what
I
it's
do
doing.
understand my
That's
bill.
what I'm actually concerned about.
It shifts
I'm
the
not
burden of
actually
proof.
hostile
It
to
shifts-
you.
Representative Harrison, you've got to let him ask the question, and then you answer.
I would,
We're gonna go back and forth.
Thank you.
Representative Dyson.
thank you, Mr. Chair. I just have a question. I'm trying to understand this bill.
Yeah.
What I'm concerned about is you don't understand the repercussions of this bill.
You've said that
I'm
twice,
not-
and I'm trying to respond to that, which
Representative
is false.
Harrison, seriously, just let him ask the question, and he'll be quiet, and then you answer. And then you'll be quiet, and he'll ask another question. Representative Dyson.
Was your intent to shift the burden of production and burden of persuasion from the corporation to the shareholder in cases involving ESG?
The bill, and I will read it, the burden of proof in the proceedings that the bill articulates in the first sentence is shifted to the corporation. I am not changing the term, I'm not changing the definition, I'm not changing the intent, I'm not changing the meaning of the three words, burden of proof. That would be a totally unrelated matter.
Okay, but, and this is where I think that there's a disconnect. So burden of proof is usually defined not in statute, but actually in common law in a lot of different cases that we have going back to the 80s. So when we discuss fiduciary duties, for example, there is a shifting sometimes of the burden of persuasion, and sometimes it's a shifting of the burden of production and the burden of persuasion. So I'm just trying to understand from your bill, are you intending to say that the corporation now must produce all the evidence to show that to disprove whatever the allegation is, and also persuade the trier of fact?
And with all due respect, I think that question would be most appropriately directed towards somebody who's trying to modify either statutory language or case law precedent on what is considered to be the burden of proof in the state of Texas. My bill doesn't change any of that.
Okay. You clearly just said that fiduciary duty claims, you brought that up when you were talking to Representative Johnson about it. I just told you there's two different aspects out there in common law right now when we deal with derivative proceedings, been involved in both of them, that sometimes you have a burden of persuasion shift, sometimes you have a burden of production. If you'd like to say, I'm not sure and I'd like to talk to you about it, that's fine, and I can move on to my next point. But I'm just trying to understand from you, do you understand if you are shifting both of those burdens, or are you just shifting one or the other? Because this is not a fiduciary duty claim from what I can tell, or is this based on fiduciary duty and ESG?
No. So again,
Okay.
I think we've got, no, hang on. I'm not answering no in that way. I'm saying there were several assertions that you made at the beginning that I am disagreeing with explicitly. Do I have a problem shifting both? No, not at all. But I'm simply making the point that my bill doesn't change anything about what is or is not considered to be burden of proof in the state of Texas. Burden of proof exists. I'm shifting it. I am not modifying in any way, shape, or form what burden of proof is.
I understand that, and I'm not asking. Burden of proof is, again, made up of two different types.
I've already answered. I'm fine with them both shifting.
Okay, so you're fine with your bill shifting both. Okay, I just want to make sure that we're on the same page. Okay, now let's kind of go through, and you started reading through the language, right, of your bill, and it says that alleges an act or omission related to improper consideration of environmental, social, and governance criteria in the performance of the act of omission. So my understanding of ESG policies, I guess now the trend is to go away from, is DEI a part of ESG policies?
I suppose it could be, but I'm talking about things that are not in the best interest of the shareholder.
But DEI, it probably is part under the social aspect of ESG, I guess.
I think there are many examples where reasonable people could say yes, yeah, absolutely.
So what about complying with government regulations? That's probably under the governance part of the policy, right?
Well, again, I think
Or even under environment?
Well, I mean, all corporations in all states are required to comply with state and federal statutory and regulatory requirements.
Right, so if they have the policy, but they had the policy there, right? And say they had that, it would be part of an ESG policy technically, even though it's probably not called ESG, but it's focused on ESG issues, and that's kind of what your bill gets at, right? You don't have to, your bill does not require a corporation to specifically say, this is an ESG policy, therefore it's now subject to this burden shifting, right?
No.
It's more about if it's criteria that would fit under an ESG aspect, then it would apply to burden shifting.
Again, it's not saying that there's any action that just a per se commission of that action would be violative of what I'm talking about here. But because it says in the last sentence that the act or omission of an act was in the best interest of the corporation.
Right. No, I get that. And so a shareholder is going to come in and say, hey, this act or omission, so part of whatever your policy is, if you didn't consider this, then I can have a burden shifting if it's under ESG criteria, right?
If that was the reason they were doing it, not if they were trying to comply with statute, as your question was predicated on.
Well, no, it's not predicated. I'm just asking because regulatory thing. But yes, that's part of ESG policy, or it can be, especially if it's environmental when it comes to certain parts.
Somebody could potentially construe that, but that's not what I'm talking about here.
Okay, but that's not what you're talking about, but it's kind of what's opened up here. And this is why I have this question for you. You know, I think you said, and I think it was a tweet about this bill, actually, that this ESG bill is to protect from the woke leftist agenda, right? Is that kind of accurate? Maybe
I
a
support-
paraphrase a little
I
bit.
support defeating the woke leftist agenda on all dimensions, yeah.
Only helps ESG supporting leftists, right? That's what
that?
your bill. You said this dishonest attempt to smear me, a cheap stunt that delays the bill, only helps ESG supporting leftists. So your
Well,
point is
to the
that
to the extent that statutes or proposed statutes such as this bill that would be a great tool in the battle against leftist ESG, the likelihood of becoming finally a passed statute is diminished, then yeah, it would help that. That's correct.
So what we just talked about, though, you do realize, right? It's a tool for those leftists that you say have this agenda to actually use and now come after corporations that are doing the right thing and burden shift to them. So a climate activist shareholder, couldn't they come after a corporation here in Texas if your bill passes and says the corporation has to prove why they don't have an ESG policy, why they omitted this out of their ESG policy, or anything of that nature? You have just now caused a great corporation here in Texas to have to accept that burden of proof. Isn't that what your bill actually
No, I
does?
think that'd be a preposterous reading. But to the extent your concern is sincere and not just grandstanding, I'd be happy to work with you on language to make sure that the language is sufficiently narrowly tailored.
Oh, I can guarantee you I don't grandstand. I think it's a little different from what you do. But I do want to know
So-
that because I care deeply about protecting the businesses that are coming here to Texas.
So do I.
We have a kind of, our agenda here in Texas has been to attract businesses. And when I see a bill like this, where either you don't understand what the repercussion of your bill is,
Which is not true.
or maybe you do have that intention that allow that and create extra lawsuits that are in there. But the thing that is, right now, what we're seeing in Delaware is people are fleeing Delaware because of ESG issues. Those same climate activists that come in, they could turn around and use your bill to attack them. If you disagree, tell me how I'm wrong in what language that your bill does not allow.
Well, as I said, we're going through a committee process. I mean, yes, we're 4 months into the session here, but we're going through a process. And to the extent that you support the intent of the bill, which I mean, I don't know if that's an assumption, I have no idea. If you support the intent of the bill, which is to make it harder for shareholders to be defrauded by management who is misallocating their capital in a suboptimal fashion to pursue social justice type causes, almost in many ways very similar to like social credit scoring. To the extent you share that goal, as I would certainly believe that you would as a Republican, I would be happy to work with you if you think that there are ways in which the language should be more appropriately tailored to accomplish that objective. I'd be happy to work with you about that.
Yeah, and I'm happy to talk to you about that. I guess that my issue here is that I don't think you've actually thought through this bill and what the repercussions of this bill would be. And you've already done, and I'll use your words, some grandstanding on it, and it concerns me for that reason that you didn't already have this discussion with me or with anybody else to kind of discuss the details of your bill.
I am here telling you right now I'm happy to discuss it with you. And as everybody who's ever worked with me knows, I have an open door, open phone policy. So if you have any questions, you could have reached out as well.
Okay, so let's go to a different aspect of it.
Representative Harrison, can I ask, I've been chair of this committee now 4 sessions, I've heard hundreds of bills. I've never had a member actively on his cell phone while he's laying out a bill and answering questions from a fellow member.
Is there a question there?
What are you tweeting? Are you texting? Why, he's trying to ask you questions
I'm not
and engage
tweeting, but I thought
hang
we're
on, let me
supposed to be-
finish. Let me finish.
Okay.
He's trying to engage you in a serious discussion about this bill.
Yes.
And you're punting on his very serious questions.
That's
You're
false.
asking us, and you're I don't know what you're doing on your phone, but you're not paying attention to him.
I am paying
Every
attention.
time the camera goes back to him, I'm watching up here.
How would
You're
I know
on
where the
your phone.
cameras? I'm not paying any attention to the cameras. You're paying attention to the cameras.
I'm paying attention to you,
you're
Representative
paying attention
Harrison.
to
I'm
the
asking
cameras.
you to please stay off your phone while you're answering questions from Representative Dyson.
I was actually looking up information related to the questions. So.
So you don't have, you have to look on your phone for answers to his questions?
No, that would be a preposterous thing.
I'm asking you with
I'm sorry,
respect.
are
with
we
respect,
supposed
you're in-
to keep our comments?
Representative Harrison, you are sitting and laying out your bill before my committee. Okay? I am asking you to stay off your cell phone while you are sitting in front of my committee laying out your bill, answering questions from Representative Dyson or any other member up here.
Should I remind you about the comments you made about the need to maintain decorum in this proceedings?
Representative Harrison, when I think about decorum, I think about a member who's laying out a bill staying off his cell phone. If you can just stay off your cell phone for just a few more minutes
This is silly.
and answer questions from Representative Dyson
I have
and
answered,
other members.
I have answered every question.
Representative Harrison, I'm asking you to stay off your cell phone
This is ridiculous.
while you do your bill layout. Representative Dyson.
All right, so kind of focusing again on this, let's take, for example, a real-life case that was filed in the Delaware Chancery Court. It was shareholder, putative class actions, a derivative suit against Meta, and the basis of the suit was that the corporation was focusing on corporate profits without considering social impact. In other words, they had omitted that part out of their ESG, and that was the basis of the lawsuit. Under your bill, do you think that that would shift the burden to Meta here to prove that they should have been considering the social impact and not just focused on profits?
Not as I understand the facts of that case, insofar as I understand them and how they may or may not be impacted by this. But again, to the extent that you have a concern about that, as I've said repeatedly, if you support the goal of giving the state of Texas every possible tool to combat ESG, which is, by the way, the official position of the government of the state of Texas, if you support that goal, I'd be happy to work with you offline about any potential emendations to the draft language that you might see fit.
Well, I'm just concerned because you just walk in here and you want to shift burdens, and that's my basic concern is when we start doing that and we start playing with who has burdens of proof when they're walking into a courtroom, I think we have to make sure that we fully understand the context here, and that was my concern with you, is that I do think that you have a lofty goal, which is to prevent kind of those activist investors that we've been talking about that bring shareholders, and you want to make it, for some reason, easier on shareholders. I do believe you have that intent. My question here really goes back to this wording in the statute. Did you think it all the way through? And that's my biggest concern here. And if I'm missing something, I'd love for you to tell me.
I'm not, well, I won't comment on whether I think you're missing something or not. That's not germane. My intent, I think, is clear from the plain language reading of the bill. It was an intent to shift burden of proof. If you have thoughts on ways, again, to the extent to which you share the goal of combating ESG, a position that is consistent with, and in fact is the position of the state of Texas, I'd be happy to work with you on any potential emendations. I've said this many times, so I'd be happy to work with you on that.
Okay.
And that's true for any member of the committee.
Vice Chair Johnson. Vice Chair Johnson. You good? Members, are there other questions for Representative Harrison? All right. I actually do have a question because I want to, just for the record, to protect the integrity of this committee, Representative Harrison, I want to be very clear about what happened last week with the bill. You were not here, right, when I called your bill up, correct? And you
As everybody knows, I was voting in another committee.
No, I didn't know that at the time. And in fact, if you will, and if you want to pick up your cell phone right now,
You
I'll
just
give
told
you
me
permission
you just told me
to do
not
so.
to touch my cell phone.
Well, I'm
so
giving you
not-
permission to do so, Representative Harrison.
Which is it?
Well, for a
Which is it?
specific purpose, I'm giving you permission to do so. And if you would like to read our text message conversation from last week when I was sitting at the dais, let me finish. When I had called your bill up, you weren't here. I immediately let you know. And I said, if you would like for me to bring it back up that very afternoon, I'm happy to do so.
That's not true.
You can talk to the parliamentarian.
That is true. You did never told me in writing or in verbal or any other communications that you would bring it up. You sent me to go talk to the Barack Obama lawyer. Okay, that's what you told me in your text message. If you want to read it, you can see that.
Representative Harrison.
You never, you
Representative
asserted
Harrison,
something that is false. You never said you're happy to bring
giving
it
you
back
permission to. I'm giving you permission to
giving you permission to
screenshot
read
that
it.
text exchange between you and me and post it.
And I'm giving you permission to do the same. You just asserted that you told me you would be happy to bring my bill back up. That is factually false.
Representative Harrison.
It's false. And
Well, while we're on the
text
record,
exchange would document that.
while we're on the record,
And while you're looking that up, I should remind you, as I'm sure you know, that your clerk, in writing to me the night before, said she would text us if my bill was coming up and I wasn't here. That never happened.
Representative Harrison, we went through the rest of the agenda. The other members had let us know. You were next in line in terms of
but
seniority.
your office told mine in writing.
I am the
that I
chair
would
of
be
the,
notified
I am
if I
the
was
chair of the
coming up,
committee, and
that
on the
did not
posting
happen.
of the agenda, as we do every week, the agenda is at the order of bills is at the discretion of the chair. And if you read back through our text, okay, I said You said you were voting in committee. I said I was not aware of that. You were next in line in terms of seniority. You can talk to the parliamentarian about getting it back on the agenda if you'd like, or we can do it next week.
Correct. And
Your
you-
response was, since you apparently formally withdrew it, next week is fine. I just want the record to
Because
show.
you withdrew it.
Representative Harrison,
And
I
you
did.
never
I
said
did-
you were going to bring it back up. You said I could go grovel to Hugh Brady. That's what your text says.
Representative Harrison,
Why
I
would
did-
I do that?
I
If
did-
only a fool would do that.
Representative Harrison,
That's what it says.
Michael, if we have the ability to turn off his mic, get ready, because I'm tired of you misleading the committee, the
I'm
public.
very used to having my mics cut off here.
Well, for good reason, Representative Harrison, because when you lie and you mislead and you deceive not only the fellow members of the House, but the people of Texas, you deserve to be called out on it, and your microphone deserves to be shut off. I never mentioned Hugh Brady, not once, not once. I said you can go talk to the parliamentarian.
Who is that?
And if you want, you don't know who the parliamentarian
The
is?
chief parliamentary officer of the House of Representatives is Hugh Brady. Hugh Brady is the chief
Excuse me,
parliamentary
Representative
officer of
Harrison.
the House of the State of Texas.
Representative Harrison.
Yeah.
And then we're going to be done with this and we're going to move on. Because there are
Great.
other members sitting behind you who are serious about their bills and witnesses who want to testify. And frankly, I'm just tired of the nonsense.
I'm here to try to
But-
fight ESG.
But
So-
for,
well, you
for
clearly
the
don't
record,
share this
Representative Harrison, for the record, I and the committee would have been happy to have you in front of our committee last week, and I expressed that to you.
You didn't have to withdraw my bill, Chairman. You
Representative
withdrew
Harrison.
it. You didn't have to withdraw it.
I did withdraw it because you were not here, and I
didn't
told you
have
you
to
could go get.
withdraw it. I've never seen that happen since I got elected here.
Representative Harrison,
For
you
a member
could have.
voting in another committee, another public committee.
All right. I am Representative Flores.
Oh, I had a question, because
Okay.
I'm trying to understand
Is
this.
it about the bill, I hope?
It is.
I'd love to get back to talking about
It-
fighting ESG. in
It
Texas.
is. So
Thank you.
if a corporation is founded on the premise of doing environmental good, or, you know, is very interested in changing the social impact of certain practices, and that's, it's in its founding, and shareholders buy into that idea and invest in that corporation. I'm just trying to understand how this works, because I'm not a corporate
Well, yeah, I mean,
lawyer.
the bill
So,
only-
so if
Okay.
somebody just buys some stock and becomes a shareholder, or gets enough stock so they can have standing to sue, they can bring an action if, say, they don't agree with the policies of that corporation, or the intent of how it was started. They can bring a lawsuit now, and then it's going to be, the burden of proof is going to be on the corporation to prove that they are in fact following, you know, their mission statement and why they were started, and all their acts and activities are based on that premise. Is that
No,
correct?
it's a very fair, and I appreciate the respectful nature of the question. Thank you very much. I'm grateful to have some of those today. And I'd be happy to talk with you about that more offline. I would look up, although I've been prohibited from looking up on my phone, the actual definitions of who Texas statute currently allows to have standing in a derivative proceeding. As I heard your question, I'm not sure that particular shareholder would in fact have standing to bring a derivative action as a result of this bill, but I'd be happy to look into that and follow up with you offline. Yeah, you bet.
Oops.
The chair will show Chairman Landgraf and Representative Gonzalez here. Members, any other questions for Representative Harrison? Seeing none, the chair will leave House Bill 872 pending at this. I'm sorry. Does anyone want to testify on, for, or against this bill? Seeing none, Chair Representative Harrison, would you like to close?
I close. Thank you, Chair.
Members, any questions for the bill's authors? Seeing none, the author is closed, and the chair will leave House Bill 872 pending at this time. The chair lays out House Bill 4266 and calls on Chairman Kitzman to explain the bill.
Thank you, Chairman Leach, and members for allowing me to lay out House Bill 4266. This bill simply adds the professional prosecutor of Fayette County to Section 46.002 of the Government Code. Most elected prosecutors with felony jurisdiction are subject to Section 46.002 of the Government Code, also known as the Professional Prosecutors Act, which provides pay equity with district judges in exchange for prohibiting the prosecutor from the private practice of law. In statute, currently there are 33 county attorneys performing the duties of district attorneys, and this bill is simply looking to add Fayette County to the list. Thank you. I'll answer questions and reserve my right to close.
coming through. Chairman Kitzman. Members, any questions on this complicated bill for Chairman Kitzman? All right, seeing none, you do have one witness. He's just registered on the bill. Okay. All right. Does anyone want to testify on, for, or against House Bill 4266? Seeing none, the chair recognizes Chairman Kitzman to close.
Mr. Chairman and members, in closing, this bill will be of great benefit to the Fayette County District Attorney's Office, and I humbly ask that members of this committee vote favorably on House Bill 4266.
All right. Thank you, Chairman Kitzman. Members, any questions? All right. Seeing none, we'll leave House Bill 4266 pending at this time. Thank you.
Thank you.
The chair now lays out House Bill 1571 and calls on Representative Jones to explain the bill. Good morning.
Good morning, Mr. Chair and members. This bill is inspired by Anthony, I won't tell you his last name, the young man at the center of the Netflix documentary, I Just Killed My Dad. Anthony shot and killed his father, something no child should ever have to do. The case revealed a disturbing history of abuse, isolation, and manipulation by his father, abuse that spanned jurisdictions and was overlooked by the system. Had Texas had a centralized protective order registry in place, courts across jurisdictions would have been able to see the warning signs and the protective orders. Conflicting court orders could have been avoided. His father most likely would have been prevented from continuing the abuse, and Anthony would never have been put in a position where he felt that he had to defend himself and violence was his only escape. This bill could have saved Anthony from trauma, prosecution, and lifelong guilt. It could have stopped the abuse before it reached a breaking point. A committee sub will be coming, so I won't lay the sub out right now, but I will tell you, this bill, which I title Anthony's Law, will amend the government code and the family code. It will require all courts to submit granted protective orders to a centralized statewide registry, require courts and attorneys to check the registry before issuing rulings or civil custody matters involving the same parties. It grants registry access to judges, prosecutors, peace officers, civil attorneys, and pro se litigants. It ensures registry access is limited to granted, expired, vacated, or active protective orders, and sealed or confidential victim information is protected. As I told you, a committee substitute is forthcoming. This bill is about prevention. It's about making sure abuse is stopped before children are pushed to the brink. It's about ensuring that no court is ever blind to the danger that already exists in another. I'll stop now and reserve the right to close.
Thank you, Representative Jones. Appreciate you bringing this bill and the bill layout. Members, any questions for the bill's author? Okay. Yes, Representative LaHood.
Thank you, Chairman. So the current law as is, what is it not doing, and what would this do?
So there is no central registry, right? So Harris County has protective orders, Tarrant County, and there's no like equivalent of like TCIC or
Yeah, NCIC, TCIC.
and so there's no way to tell. So in Anthony's case in particular, it happened in Harris County, and one of my good friends was Anthony's mom's lawyer. She had a protective order in Harris County, and they had a custody battle, and she was the managing conservator, the sole managing conservator. Anthony's dad kidnapped Anthony and ran away to Louisiana, where he was from, so he basically forum shopped. And then when he got to Louisiana, he told them there was no litigation pending, and there were no protective orders. And he alleged that mom was the abuser. So he gets a conflicting order in Louisiana. Mom didn't know about the order, right? Because she was excluded. And so he ends up having Anthony for all those years. He continued to abuse Anthony. Anthony ended up having to kill his dad. Now, by the grace of God, Anthony was acquitted, but I mean, so he might have beat the legal rap, but he certainly didn't beat the legal ride. And so this will force attorneys to go look at the registry, certify that they looked at the registry, and it'll force courts to do that as well, so that this could never happen in the future. So this, I guess the longer answer to your question is, it will create a centralized registry where everybody could go look to make sure that there are no existing orders.
Is it just for active protective orders, or would it include expired protective orders?
Yes, all of that, because, you know, you need to establish a history. Sometimes when you're abused, you actually don't call the police. So the only person who knows that you've been abused is you. So it will make it easier to get protective orders in the future if you need them, because sometimes they expire. Sometimes you get lifetime ones, but other times you don't. And so it will just help close a loophole that's just exists in law right now.
Thank you.
Thank you.
I have a question, sir. Sorry. Yeah, you mentioned that he went to Louisiana. So if there had been a registry here in Texas, how would the judicial system in Louisiana been able to see that there were protective orders in Texas?
Because it allows judges, courts, litigants, pro se attorneys to go check.
Even interstate? I mean,
Yes,
like
and I'm also looking at the interstate compacts to just sort of see, but I think this definitely would have been a game changer insofar as that is concerned. But I would ask you to go look at I Just Killed My Dad.
Okay.
It's really a tragic.
To follow up, I like the intent of this and what you're trying to do, because I think it's very important to be able to protect people against abusive folks. And if somebody, or stalkers or whatever history there is that makes that person need a protective order from somebody who is an endangerment to them. But I noticed that there's a fiscal note, and is the OCA prepared? Have you spoken with them about being able to absorb the costs?
So we're looking at that right now.
Okay.
Right, we're looking at that right now, but I mean, any death is too much.
Yes.
Right, nobody should die. You certainly shouldn't be able to form shop. And Anthony, what he had to endure for the period that he was with his dad, you know, after his dad kidnapped him, shouldn't happen. So we're going to try to figure that out.
Okay, I thank you very much for your bill.
Members, any other questions for Representative Jones? Does anyone want to testify on, for, or against House Bill 1571? Seeing none, Chair recognizes Representative Jones to close on the bill.
Mr. Chair and members, I prayerfully request your favorable consideration with the committee sub when we lay that out that way.
Okay.
But thank you.
Okay, great. Thank you. Members, any questions? All right, thank you for being here. The chair will leave House Bill 1571 pending at this time. The chair lays out Senate Bill 1719 and recognizes Chairman Smithy to explain the bill.
Thank you, Mr. Chairman. This is a bill that Senator Hughes had over in the Senate, and it's a bill that he and I have talked about over the years that a lot of legislators aren't even familiar with. But so back before 1939, the rules of civil procedure were basically in statute. The legislature adopted the rules of civil procedure as statute. So in 1939, we began allowing the court to promulgate rules of civil procedure. And so we put a provision, or the legislature back, I wasn't in the legislature in 1939, I came a few years after that. But the legislature put a provision in there that said that substantive law is repealed because there was a lot of substantive law that dealt with civil procedure. That was the intent of the bill, but we've left in place over the years this provision that says the Supreme Court can actually repeal law that we have passed in the legislature by rulemaking. Now, it just applies to procedural law, but there's not always a fine line between procedural law and substantive law, and so it creates some confusion. Over the years, we have passed some bills that dealt directly with procedural law. I'm trying to think of a few, offer of settlement. There's some others that we've done that have actually gotten into procedural law. Generally, the court will follow up that with rules that are consistent with our statute and honestly has tried to avoid these conflicts. I don't know of any occasion where the court has just overtly tried to override or supersede or negate any law that we've passed, but certainly that provision is there. It, in a lot of people's opinion, I think in a lot of the justices' opinion, it threatens the separation of powers clause to say that the court can overrule the legislature in these matters. And I think it also provides this clarity to practitioners and to litigants that that the law passed by the legislature, statutory law, whether it deals with procedure or substance, it prevails. And so this just seems to be a glitch that has remained in the law now for almost 100 years, and that probably should be corrected. Be glad to address any questions.
Okay. Members, any questions for the bill's sponsor? All right. Sit tight. Does anyone want to testify on for or against Senate Bill 1719? Okay, seeing none, the chair recognizes Chairman Smithy to close on the bill.
Thank you, Mr. Chairman. With that, I'll close. Thank you.
All right. Members, any questions? All right. Thank you, Chairman. We'll leave Senate Bill 1719 pending at this time. The chair lays out House Bill 4559 and recognizes Representative Olcott to explain the bill. Welcome. Good morning.
Good morning. Thank you, Mr. Chair,
Yep.
members. Yeah, I have a really simple bill. After being appointed to the DOJ committee, some colleagues and I on that committee began going through code and identified the following code. Let me pull it up right here. Chapter 668 in the government code used to regulate membership dues, and it no longer does that. And actually, that whole chapter has been deleted except for a simple definition. And all this bill does is simply eliminate that definition.
Okay.
Because the definition doesn't apply anymore. And I don't know why it was referred to this committee, but it's more than happy to. Should be in DOJ committee.
I'm not sure where.
Oh, no, I'm very happy to be here.
Yeah, we're
I
happy
got some
to have you
hostile
here.
members in my own DOJ committee, so this is a very friendly committee. So all this is doing is simply trying to eliminate an unused and unnecessary code. It's a simple definition, and it doesn't apply anymore.
So tell me a little bit more about how you came up with the bill idea. You mentioned that you and a couple other members on the DOJ committee were looking at stuff, which is great.
Code.
That's the purpose of the DOJ committee, obviously, among other purposes. But tell me, what happens if we pass your bill?
We eliminate Chapter 668 entirely. It's actually almost essentially, the whole code has been eliminated except for except 668.0, except 668.001, which is a simple definition that no longer applies.
Okay.
So
And
the
that's
chapter
definition
heading.
That's the definition for, quote, state agency, is that right?
That's correct.
Okay. It almost seems overly, it almost seems too simple.
I know.
Members, are there any questions?
So there are,
Yeah, Representative
so there are
Flores.
no references in any other laws that reference this particular
No.
statute from that code? So this
No.
would just eliminate it and it would just be done with?
That's correct. And the bill that's laid out in front of you right now is the original filed version. It was not a ledge council draft.
Okay.
I have a ledge council draft back, which will be a committee substitute, but I've been told that I can't lay that out yet. Is it improper to relay the new caption that came up from ledge council that actually?
Yeah, it probably is.
Okay.
Let's stick with the bill as
Yeah,
is, but
sure.
when you get us the ledge council version of the bill in committee sub form,
Yes.
we'll take it up, and as long as it's the same intent of the bill, which it clearly will be,
Yes,
then,
yes.
then we'll take it up as pending business, which Representative Olcott, I plan to do tomorrow.
Okay.
At some point, so if you can get us that sub today.
Yes, I've got it. I've got it right
I
here.
think this
but-
committee.
Yes, sir.
I just want to let you know, I really appreciate, you and how hard you've been working on issues you care about, and I know this, you might have been surprised as us that this came to our committee, but we cut government here too, proudly so, and so I'm glad you were able to
Yeah,
come.
well, I'm just glad y'all have the opportunity to help pass some earth-shaking legislation. So.
Yeah. Members, any questions for the bill author? All right. Does anyone want to testify on for or against House Bill 4559? Seeing none, the chair recognizes Representative Olcott to close.
Yep. Yeah, I close. Appreciate
Okay.
your
I
favorable
think this
consideration.
ties with one of the other bills. Oh, Kidsman's bill, I think, for simplest bill
Simplest bill of
ever.
the, yeah. All right, thank you, Representative Olcott.
Thank you, Chairman.
Appreciate it. We'll leave House Bill 4559 pending at this time.
Thank you.
Hey, Lulu, Representative Flores, can you grab Leilani?
To Cassidy. Okay, thank you.
Is he? Is he coming? Okay, the chair lays out Senate Bill 441 by Hinojosa and recognizes the bill's sponsor, Representative Leilani, to explain the bill.
Good morning, Chairman Leach.
Good morning.
Vice Chair Johnson and the committee members, and thank you so much for allowing me to lay this bill today. This is originally a bill from Senator Hinojosa. The misuse of AI to create non-consensual intimate visual materials, often called deepfakes, has grown exponentially. The report indicates that 96% of deepfake videos online are pornographic, targeting women disproportionately. In 2023, cybersecurity researchers found that searches for deepfake pornography increased by 900% within 2 years. Victims face severe emotional and reputational harm, compounded by lack of clear legal remedies. The issue escalates with platforms hosting nudification applications which use AI to digitally undress photos without consent. Current laws fail to address these AI-specific harms adequately. SB 441 builds on prior initiative which criminalize non-consensual disclosure of intimate images but does not amount for the AI-generated content. This bill closes the gap by addressing a unique challenge of AI misuse in creating and distributing intimate visual materials. Expands the scope of Chapter 98B to include artificial intimate visual material, defining it as a computer-generated intimate content created or modified using AI. Adds terms such as nudification application, AI designed to create artificial intimate material, and social media platform for clarity. Liability for the AI-generated content holds individuals and entities liable for damages if they produce, solicit, disclose, or promote artificial intimate visual material without the depicted person's consent, intending to cause harm. Makes the website owners and payment processors liable if they facilitate the production or disclosure of the non-consensual artificial intimate material and fail to remove such material within 72 hours of a removal request. Allows claimants to use pseudonyms to maintain confidentiality throughout the lawsuit process. Sets a 10-year limitation for filing lawsuits starting from when the victim discovers the material or turns 18. I'm happy to answer if you have any questions. Otherwise, I reserve the right to close.
Thank you, Representative Leilani. Members, any questions? Is Hayes here? We don't. Members, any questions? All right, seeing none, you've got two witnesses who've registered to testify on the bill. The chair calls Brody Burks and Camille Cook. What's your name, sir?
Brody Burks.
Okay, you're resource witness from the AG's office?
That's correct.
Great, we're glad you're here. Is Camille Cook here? Mr. Cook, or Mrs. Cook. I don't know if it's a public citizen registered for the bill but wishing not to testify. Brody Burks, I have you here on behalf of the Office of the Attorney General registered on the bill. Is that correct?
That's correct.
All right, go ahead.
Chairman, members, thank you so much for having me today. I'm here to answer any questions primarily, but part of what I want to let y'all know is what we are seeing in this area. Really, with these kinds of images, we are seeing these in sextortion schemes where people are creating nude images, largely targeting children, but sometimes adults as well, and using those images to extort them for money, for additional nude images, things like that. One of the things that we're really excited to see in this is the ability to have a process to have it removed from websites and go after those websites that are hosting it, because oftentimes what we are finding is that we don't have a lot of criminal hooks that we can put in these kinds of things.
So is that provision in this bill?
Yes, it is.
And how does that relate to the federal, the Take It Down Act, I think that just passed? I think that's Senator Cruz's bill that just passed the United States House and is moving, I think. How does those two statutes work together?
So I am not familiar with the Take It Down Act in the terms of the process that it creates. I know that it exists. What I will say is that we are already seeing some of that through the National Center for Missing and Exploited Children. They have a program called Take It Down that they've already partnered with Meta, Instagram, TikTok, and some others that creates a process where we can go through NCMEC, send them a hash value and say, hey, this is being used, it's either child pornography or it's being used for child sexual exploitation, and then have that blacklisted on their site. So I'm envisioning that a process would work similar to that.
Okay.
But because we often don't have criminal hooks that we can put in this, because many times we are finding these are overseas actors, they are people that are simply beyond our jurisdictional reach, to be able to go to a website and say, hey, will you take this down? And if you don't, we now have some civil remedies that we can go after. Those are some really important tools in this fight for us.
So I have a question. I've asked this on another couple bills that we've had relating to this issue, and you may or may not have the answer to this, but I've heard of the situation. Prosecutors have described the troubling situation where, specifically when it comes to child pornography, you have to have an identifiable victim. And what's happening with these deep fakes and the production of these artificial images is you've got a real child's face, and then another real child's body put together, so there's no one victim. In that situation, number one, is that a problem? Do you have the tools you need to prosecute those individuals? And then who is the victim in that case?
Right. So the answer is no, we really don't. There are several bills this session that are pending that I think will get us much closer to doing that. So I think the answer is not right now. I may have to get back with you on September 1st to let you know what actually gets passed and signed and whether.
Yeah, I know there's some other bills that are addressing that.
But in that case, currently, we would really not have a named victim. It would be very difficult for us to go forward on a case like that and name one child or the other without some pretty substantial questions of factual sufficiency going forward on appeal.
Yeah, it's very troubling. We heard about these instances in the Select Artificial Intelligence Committee, and then in this committee on a number of bills as well. So, yeah, we'll figure out where those bills are in the process and look forward to hearing back from you in terms of what other tools you need to go after those guys. Chair will show Chairman Dutton here. Representative Flores.
So this bill then, as a tool, once somebody is identified or identifies themselves and reaches out, says, yikes, here I am, and so then you would be able to then recover they would be able to recover civil damages for that image that's been put out there?
That's correct. So really there's two actors in this bill that we could pursue. So one is the person who actually creates, distributes, the person that is doing that harm. But then the second is if that image is being distributed through a website, whether that's Twitter or Instagram or whatever that is, then there is a process that this bill requires that the victim could notify the website and have it taken down. If they don't take it down, then they can go after the website for that harm. I think that's really the important part for us, is because it gives us some relief, somebody to actually go to. Like I said, we often don't know who the person creating the image is, or they're beyond our reach, but we can at least keep that harm from snowballing.
So the AG's office would then take on these cases, but there would also be a civil lawsuit taken by a private attorney, but you would go after the wrongdoer, the state would go after the wrongdoer?
So this creates a private right of action. The Attorney General's office would probably not be involved in that piece of it. But what it would let us do is talk to our victims when they come to us, when we're having one of these discussions, and say, we can't do this for you, but please know that this exists. In the same way that if you have a victim of sexual abuse through some organization, right, we have seen where sexual abuse victims have been able to sue a specific church or civic organization or something like that that is harboring their abuser. That's not something that we can do, but it is another tool that we can make them aware of to become whole again.
One last question.
Sure.
So you wouldn't go after the website that refused to take it down as a bad actor? Is there any action you can take against that actor, or is that up to a DA or somebody in the jurisdiction where they reside, or, I mean, how would that work?
Right. So what I would say is that would reside probably within our Consumer Protection Division rather than within my own division. I'm a professional prosecutor. I prosecute these sorts of cases throughout the state. My civil expertise is fairly limited. We do have a couple of civil attorneys in our office who right now are mostly working on illicit massage businesses. That is something that we might be able to do, but I think that would probably lie within our consumer protection.
But you could take action to shut them down?
Yes.
Okay, thank you.
Members, other questions on this bill? All right, thank you. We really appreciate you being here on behalf of the Attorney General's office. Oh, hold on. Representative LaHood? Representative LaHood.
Just one question, thank you.
Sure.
Is AI, in your experience, advanced enough to artificially create an image that looks real?
Absolutely, 100%. There is a website that I would point you to. It's thispersondoesnotexist.com. And if you just type that into your web browser, thispersondoesnotexist.com, and every time you hit refresh, that is going to give you another like headshot. There no illicit images or sexual images, but it will give you a headshot of someone who does not exist. It is completely an AI-generated image, and you can just hit refresh until you get one that you like and want to use as your avatar on X or whatever. And sometimes when you start to look at them, there is an example that I use in some of my training PowerPoints that it looks like AI started to give the guy an earring and then didn't. And so you can start to look at them and go, well, okay, maybe. But if you were just looking at it, it's going to take a lot of concentration to figure out that it's AI, not a real person.
Yeah.
Thank you.
It's it's truly unsettling and shocking what is happening with AI. Representative Flores.
Yeah, not related to pornography or those kinds of images, but I just got word of something going on in another state about requiring, and I'm looking into whether there's a bill out there that perhaps that would require AI that's created to carry a tag, like almost like a copyright tag or something that says this is AI, so that consumers are not fooled, or that they have upfront knowledge that what they're looking at is actually an AI image and not real.
Yeah, our assistant clerk Michael here has pulled that website up on his screen. Members, I know a couple of you are glancing over here, but it's shocking. It's truly. I know you can't see it, Mr. Burks, but it's exactly what you said it to be. Wow. All right, members, any other questions for the resource witness? Okay, thank you for being here.
Thank you.
Does anyone else want to testify on, for, or against Senate Bill 441? Seeing none, the chair recognizes the bill's sponsor, Representative Leilani, to close on the bill.
Thank you, Chairman and the committee members. It's exciting that we are having some engagement on this bill. Representative Flores, about you were asking if there is something that can have a tag on. I'm not sure if I am able to talk about different bill, but there is a bill which is called Provenance Bill. I had it, it's passed another committee, is on the calendar. And it does is digital data tagging. So if you have a small dot, you press it, it'll say which IP address it was created, anything was updated or not, edited, and AI was used or not. So it just gives more credibility and where this was generated from.
Okay, I'll talk with you offline on that.
Yes.
Thank you so much.
And Chairman, thank you for your questions. We are working with the Senator's office to make sure that this bill conforms with the federal regulation.
Okay.
And we may bring the sub or the amendment on the floor.
Okay.
To make sure that happens.
Okay, great.
Any other questions?
Members, any questions for Representative Leilani? Okay, thank you.
Thank you, I
for being
close.
here. The chair will leave Senate Bill 441 pending at this time. Members, we've got two remaining bills. Chairman Buckley's Senate Bill 251, and then my House Bill 4713. I have to go lay out a bill on elections. I'm going to let Vice Chair Johnson lay these out and then conclude our committee's agenda for the day. We will do a formal meeting tomorrow to vote on pending legislation. So thank you, members, for a great committee hearing, as always. These are really good bills. These bills were done. Yeah, there's no witnesses.
All right, the chair lays out Senate Bill 251 and recognizes myself to explain the bill on behalf of Representative Buckley. Thank you, members, for the opportunity to lay out Senate Bill 251. 251 is designed to address the increasing criminal caseload in Bell County by establishing criminal law magistrates. By appointing magistrates, Senate Bill 251 aims to expedite proceedings for individuals detained in county jail, ensuring they receive timely hearings and legal counsel. This approach aligns with the principle of providing swift justice, particularly for those awaiting trial. The Commissioners Court of Bell County will be granted the authority to appoint magistrates to serve the courts, and they will be able to use their authority to give preference to cases involving individuals held in county jail. Happy to take any questions and reserve the right to close. Members, any questions on Senate Bill 251? Any questions? No. Is there anyone wishing to testify on, for, or against Senate Bill 251? If not, the chair recognizes myself to close on behalf of Chairman Buckley. Thank you, members. Ask for your favorable consideration for Senate Bill 251. Any other questions? All right, thank you. Hearing no objection, Senate Bill 251 will be left pending. Hearing no objection, Senate Bill 251 will be left pending. The chair now lays out House Bill 4713, again recognizing myself on behalf of Chairman Leach. Members, in Texas, there's uncertainty existing regarding the statute of limitations applying to arbitration proceedings under the Texas General Arbitration Act. During the 88th legislative session, House Bill 1255 by Representative Smithy was passed into law, offering important statutory clarification regarding the statute of limitations as they apply to arbitration. However, over the intervening biennium, practitioners in the field of alternative dispute resolution have recommended changes to the statute to clarify and to make it more accessible to both legal practitioners and the general public. House Bill 4713 amends the Civil Practice and Remedies Code to clarify that a claim subject to arbitration is governed by the same statute of limitations period as if the claim had been filed in court. This bill specifies that initiating a claim by filing suit in a court of competent jurisdiction tolls the statute of limitations for arbitration of the same claim. This measure ensures consistency in the treatment of claims between court and arbitration proceedings regarding applicable limitation periods. House Bill 4713 seeks to clarify this ambiguity by explicitly providing that filing suit in court tolls the limitations period for arbitration of the same claim. I'm happy to take any questions.
So are
Representative
these
Flores.
like simultaneous motions or something? I mean, I don't know if you file and I don't know anything about arbitration, maybe that's why I'm asking the question, but if you file a suit in a court and it's to tolling the statute of limitations, but you haven't, so this would just say if it's not supposed to be in the court and it's supposed to be pursued through arbitration, then that mean that, so that same date would apply to the arbitration if they initiated that process instead? I'm not sure I understand.
That's my understanding of it, and
Okay.
you see it in context. I think when people are discussing waiver of arbitration provisions, they may have filed into a court thinking that they could get in there, and but then they get a ruling that goes the other way, and it's just to make it clear that told it why it was there. So then if it gets kicked out and has to go into arbitration, that they can't then claim that you didn't meet the statute of limitations by filing arbitration in time. That's my understanding. It's not my bill, but that's the way I understand it. So,
Thank you, Representative Dyson. Any other questions?
So that just means that it's timely filed. So it won't dock you, because if you don't discover for 6 months that you filed it in court and you should have gone to arbitration, it says, so if you filed it in court, it'd say, no, well, that's gonna say that's gonna toll the statute there.
yeah,
and-
that's the way I read and
Okay.
understand it. So,
Chairman Dutton.
Yeah, well, the other side of that is sometimes parties wait and the statute of limitations is about to expire. And so they'll go ahead and file a lawsuit to save the case. That results in sometimes having to force the arbitration proceeding. And so that's what happened most of the time.
Members, thank you for the dialogue. Is there anybody else that wishes to testify on, for, or against House Bill 4713, and recognizes Speaker Pro Tem Moody to ask a question for Mr. Dyson?
I'm
Take it
actually,
back?
I'm gonna do that offline, if you don't
Okay.
mind.
All right,
Madam Chair,
sounds
thank
good.
you so much.
All right, again, is there anybody else that wishes to testify on, for, or against House Bill 4713? Seeing none, I recognize myself to close on behalf of Chairman Leach, and I close. Members, any other questions? If there is no objection, House Bill 4713 is going to be left pending. Hearing no objection, the chair leaves House Bill 4713 pending. Members, this concludes today's agenda. Is there any further business for the committee to address? If not, the chair moves to adjourn. Is there any objection? Hearing none, the committee stands adjourned, subject to the call of the chair.